Good morning. My name is Marissa Cohen. I'm a law school graduate, and I'm going to be pursuing my master's in constitutional law, become a law professor. And normally, I write instead of putting out videos. And I didn't want to do that because I wanted to express my opinion, and I wanted to express some emotion about a case that I never heard about, and I doubt most people did. But the Supreme Court of the United States handed down fairly useless opinion on June 28th, 2021. Now, a lot of people don't read Supreme Court opinions. Why? Because they're inaccessible. The language used is not for everyday people. And I believe that's on purpose, to keep people from accessing the information and understanding what the highest court in our land is doing. And this opinion is no different. The first phrase used is per curiam, which in itself involves a Google search, and now it's a two-step process, and it's a turnoff. But this case is Lombardo versus the city of St. Louis, and involved an incident where a man, Nicholas Gilbert, failed to appear in court for a traffic ticket, and an arrest warrant was issued. He was arrested and brought to jail. This case involves his death while he was sat on in the prone position. Now, if that sounds familiar to you, because that's how George Floyd was murdered. But what makes this case so significant is that Gilbert died in 2015. 6 years ago, Gilbert died in the prone position from being sat on. And the 8th Circuit in St. Louis, Missouri, heard the case and decided that summary judgment, which means we're not even going to hear it, we're just going to throw it out. The excessive force claim that the parents brought was thrown out, giving the correctional officers who killed Gilbert the benefit of the doubt, and not inquiring into the facts and circumstances of the incident. So I'm going to give you a little background and read you some of the words that the court stated. Now, per curiam means it's a unanimous opinion of the court, which technically doesn't even make sense in this case, because there's a dissent by a conservative justice, Samuel Alito, who was appointed by George W. Bush, and is an advocate of police rights, of more punishments for criminal offenders. I think he's one of the most damaging things about the Bush presidency, but that's a personal belief. But on the afternoon of December 8th, 2015, Nicholas Gilbert was brought into jail for failing to appear for his traffic ticket. Again, keep in mind, a traffic ticket. Now, Gilbert is 5'3", 160 pounds, probably the size of most of your grandfathers. And when he was in the cell, he ripped off a piece of his clothing and tried to hang himself. Now, after his suicide attempt, correctional officers entered his cell. At this point, we have 3 officers and Gilbert. The 3 officers attempted to handcuff him. They succeeded in handcuffing him, and then they tried to get him onto his concrete bed and handcuff him to one of the stems holding up the bed, the legs. They fail to get him attached to the leg of the bed, and at which point Gilbert is thrashing around. He is upset. His suicide attempt has failed, and now he is being handcuffed, and they're trying to force him onto the leg of the bed. While he's thrashing around, he kicks one of the officers in the balls. I kind of understand that, but at that point, the officers call for backup, and they call for leg shackles. Now, leg shackles are something that was not used on Floyd, though it was considered, and in effect, they did use shackles by putting men on Floyd's body, but in this case, what they did was they called in more men. So we have 6 officers in the room now with the man who had attempted to kill himself, who was handcuffed behind his back. They force him onto his stomach. Now, on his stomach is handcuffed behind his back, and what they do is they bend his legs and they force his ankles onto his rear end, and then they put a form of handcuffs on his ankles and connect the thing holding his ankles together to the handcuffs on his wrists. So now he has his legs behind his back, he has his feet on his rear end, and all of that is connected. So he has no access to using his limbs. All he can do is roll around on his stomach. So at which point he was handcuffed and in the leg irons. 3 officers held his limbs down. Now, what the court classified as was there was one man pushing his shoulders down, another man a little further behind that man pushing his biceps and his elbows into the ground, and then another man pushing his shins down, forcing his hip bones basically into the ground. So now we have 3 men sort of stacked on him. Gilbert, at that point, is struggling to get his face off of the ground, to get his chest up so he can breathe. Now we have 3 men. 4th man then sits in between the upper 2 men on his back and torso, and he's sitting as I sit on my couch right now, as if he's on a park bench, just sitting. And he does that in order to stop Gilbert from yelling, "It hurts. Stop. It hurts. Please stop. It hurts so much. I can't breathe." And they stay, those 4 men, including the one sitting on him, they sit there for 15 minutes. And the men were aware that he was wheezing, that his breathing had become abnormal, because they testified to it. They wrote reports about it. And after all that, he stopped speaking. He stopped moving. And then, after 15 minutes, they rolled him onto his side and checked for a pulse. And they didn't find one. And they called an ambulance. And the court wrote, "Find F's to the pulse. Finding none, they performed chest compressions and rescue breathing. An ambulance eventually transported Gilbert to the hospital, where he was pronounced dead." Gilbert's parents sued, alleging that the officers had used excessive force against him, and the district court granted summary judgment in favor of the officers, concluding they were entitled to qualified immunity because they did not violate a constitutional right that was clearly established at the time of the incident. The parents appealed, and the 8th Circuit held the same exact thing. So now we're in the Supreme Court, and they're saying that this is excessive force and it was against Gilbert's constitutional right. Again, he's 5'3" and 160 pounds and has 4 people on him, and he was sat on for 15 minutes. And so, in assessing the claim of whether the officers were using objectively reasonable force on him, they used the Graham versus O'Connor standard, which we heard tons of things about in the George Floyd case, and that's, again, a useless standard. It's useless because it says objectively reasonable. I don't know what that means. Because if this is objectively reasonable, then I don't know what reasonable means. But what the lower court, the 8th Circuit, which said that the officers were subject to qualified immunity, that's the highest court in the area before the Supreme Court, they did not consider Let's see what they didn't consider. Some pretty good stuff. The court did not consider the use of the prone restraint, the kind, the intensity, duration, or surrounding circumstances. They said, the court, Eighth Circuit, said it is per se constitutional to use the prone position so long as an individual appears to resist officers' efforts to subdue him. So what the court's saying is length doesn't matter, how we got him in that position doesn't matter, what was happening at the time, how intense the use of force was in the prone position. The Eighth Circuit said that does not matter so long as the person's resisting. Now, the court went on to say that these facts as to intensity and all the circumstances were, quote, insignificant facts. So the Supreme Court now is wondering whether or not that court opinion from the lower court is correct. And the Supreme Court's answer to that was, well, we don't know if they were right or wrong. So we're going to send it back for this same terrible court that found those facts insignificant to now listen to those facts and not just give the officers the benefit of the doubt. So what the lower court was saying was, we don't need to consider these things. We give officers the benefit of the doubt. They have qualified immunity for anything. And what the Supreme Court is saying is, I don't know. Can you look at these facts again? Now that's nice. So what the court said was that the police had well-known guidance recommending that officers get off of the subject's stomach as soon as he was handcuffed because of the risk of asphyxiation. The guidance to these correctional officers also said that struggles of a prone suspect may cause death because of oxygen deficiency, and that it should only be used when someone disobeys an officer's commands, but once he is subdued, you get them out of the restraints. This is in the Supreme Court opinion, right? I paraphrased that last bit because it obviously didn't sound like legal language. So, the Supreme Court said such evidence, when considered alongside the duration of the restraint and the fact that Gilbert was handcuffed, legs shackled at the time, may be pertinent to the relationship between the need for use of force and the amount of force used, the security problem at issue, and the threat to both Gilbert and others reasonably perceived by the officers. Having failed to analyze such evidence or characterized it as insignificant, the lower court's opinion should be read to treat Gilbert's ongoing resistance as a controlling matter of law. Such a per se rule would contravene a careful, context-specific analysis required by this court's excessive force precedent. We express no view as to whether the officers used unconstitutionally excessive force, or if they did, whether Gilbert's right to be free of such force in these circumstances was clearly established at the time of death. Instead, we vacate the judgment of the Eighth Circuit and remand the case to give the court the opportunity to employ an inquiry that clearly attends to the facts and circumstances in answering these questions in the first instance. So the court says you have to look at everything. Go back. This case involves an incident, like I said, in 2015, 6 years ago, 5 years before George Floyd's death. Now, I hadn't heard about this case until I read this opinion. But had anybody cared, listened, or a lower court actually having found 4 men on top of somebody unconstitutional, Floyd could be alive today. Floyd's death was due to a fake $20 bill. Bought cigarettes with a fake $20 bill, and he died for it. Nicholas Gilbert was a 5'3", 160-pound white male, which is again surprising why we didn't hear about this, but white male who was in there for a traffic ticket, attempted suicide, and then was killed by 4 correctional officers in his jail cell. And the highest court in our land couldn't even look at that and say that's unconstitutional. They said go back and look at this, and don't make any rules that cops or correctional officers always have immunity. You can't do that, they said, which is nice that we now have a gap. But they didn't make any real change. They didn't do anything necessarily. They just said, look at it again. And a court that was so sure of itself to not even hear testimony and to say that the facts that I mentioned were insignificant because correctional officers always have immunity. How do you think they're going to rule seeing it again? What are they going to do? They're going to sit there and listen. And they're going to say, well, we were right the first time anyway. This man was thrashing around. He was upset. They had the right to subdue him for 15 minutes sitting on him. And he died. He died for it. And he died 5 years before George Floyd did. And had anybody been aware of this, had any changes in training for correctional officers or police officers been implemented, Floyd could be alive. Because you think about it, they have yearly training. 5 years before Floyd's death, that means there were 5 chances to let people know that this behavior was unacceptable. Because it's in writing. It's a fact. Nicholas Gilbert died. And nobody did anything. So, what I want us to do with this information is to realize that Floyd's death is clearly not an isolated incident. We know that. We know that we didn't need this opinion to tell us that this type of behavior is happening every single day. But we do have proof that our government officials are not doing enough. Supreme Court's not doing enough. Police are not implementing new training procedures. Correctional officers are not getting new training. And because of that, this will repeat. This will keep happening. And like, I haven't heard about this, and likely many people haven't. We're not going to hear about every time somebody is killed like this. So what we can do is keep listening, stay involved, engaged, educated, keep learning. Learn about all of this. And make sure your voices are heard. Don't become complacent. Don't just let things continue. We have to lead. We have to be leaders, and we have to be involved. Because dying for a traffic ticket, dying for a fake $20 bill is not appropriate. And in my view, it's not constitutional. And I'm willing to make sure that I educate law students about this. But everybody needs to be educated about this, and everyone needs to know about cases where a man is sat on for 15 minutes until he dies, and correctional officers are told it's okay. Your behavior did not violate any of his rights. He did not have rights to live that day because of his traffic ticket. So, get engaged, stay involved, and I hope that everybody learned something today. Thank you very much.